You just can't seem to follow the rules.
She kept chasing me. That's it. And then she went to talking about calling the police and all that. That's she control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
You just need to just stop blaming them.
All right, guys. Today we've got a seriously intense courtroom moment featuring Judge Simpson and a defendant who just cannot seem to stay out of his own way. This guy is back in court after allegedly tampering with his tether device and meeting up with the same woman involved in his prior domestic violence charge. Not exactly a smart move when you're out on bond. Judge Simpson does not hold back. He goes in on him for blatantly ignoring court orders and acting like the rules don't apply to him. If you're on probation or bond, messing with a tether is basically asking to be sent straight back to jail. And instead of taking responsibility, this defendant comes loaded with excuses. This hearing gets heated fast, and Judge Simpson makes it very clear he's had enough. Let me know what you think about this court hearing in the comments as we watch Judge Simpson lay down the law. Let's dive in.
Mal Carter. Thank you. Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case, however.
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know. You're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already.
It's a charge of interfering with electronic communication device, the 2-year felony, and then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honor's indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
I get that the defense attorney is doing his job and trying to minimize the damage. That's what he's there for. But if we're being honest, this defendant dug this hole himself. It's not like he misunderstood the judge's warning. He didn't just bend the rules. He basically walked out of court, looked directly at the court's orders, and decided they didn't apply to him. When a judge tells you to stay in your lane and you immediately cross it, you're practically daring the court to respond. It's like getting warned once and then turning around and doing the exact thing you were told not to do. That's not a misunderstanding. That's a choice. And now he's standing there acting surprised, like this outcome came out of nowhere. But judges, especially someone like Judge Simpson, don't forget clear violations. When you tamper with a tether or violate bond conditions, you're not just bending rules. You're challenging the authority of the court itself. If he walked in thinking he could talk his way out of it, he's probably about to learn that accountability hits a lot harder than excuses. Something tells me this is going to be a serious wake-up call, and he may not be walking out of that courtroom the way he walked in.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So later, and I will tell the court after review of the police report, the person representing themselves to be the defendant, they had contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the defendant, because the police officer was speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person called him back or presented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the score for probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation about the probation and sentence the defendant to serve balance at this time. And in bond in this case, we're asking for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. Better, I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't, but
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
Simpson, I said something.
You can say whatever you want.
I understand.
Oh, this is about to get wild. So let's break this down for a second. This guy has an active restraining order against this woman. The last time he stood in front of the judge, he was clearly told to stay away from her. Not keep your distance if it's convenient. Not only text a little. He was told to stay far away, no contact, no meetups, nothing. And now he's been caught meeting up with her and somehow thinks he can explain his way out of it? This is where it gets interesting. Because whatever excuse he's about to give has to be absolutely unbelievable. There's just no realistic way to spin this into "not my fault." But you already know he's going to try. At this point, the only thing left would be claiming he was dragged there against his will, because anything less is going to sound ridiculous. And standing in front of Judge Simpson after blatantly ignoring a restraining order? That's not exactly a winning strategy. Let me know what you think he's about to say here, because whatever comes out next, I have a feeling it's going to be next level unbelievable. Buckle up.
She put up on me. I was in the room playing my game, and she came in the room. And
Then you get up and leave.
tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car and that's when I pulled off.
Well, maybe that's all gonna come out, Mr.
I
Thomas
understand.
Carter. Maybe that's all gonna come out. I let you out the last time. Should have of all rights locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is.
I
You have got all of these charges.
understand. I take
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety on his other matter. Anything you want to say before I post sentence on that case?
I want to say I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. I understand it. When I get out this situation this time, I'm gonna be by myself. I just know
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Dawn Farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in-jail DV program. Is what I meant to say. Thank you. Defendant's remanded.
And that right there is exactly why you follow court orders. Everybody makes mistakes. People mess up, make bad choices, and sometimes realize afterward, yeah, that was dumb. But it's a completely different situation when someone gets warned by a judge, clearly, directly, and then turns around and does the exact same thing again. That's not confusion. That's a decision. At some point, it stops being a slip-up and starts looking like a pattern. And when a court sees a pattern of ignoring orders, especially something as serious as a restraining order violation, the consequences escalate fast. In most states, violating a restraining order is a criminal offense, and depending on the circumstances, it can absolutely mean real jail time. Now, let's talk about Judge Simpson for a second. He does not tolerate blatant disregard for his orders, and honestly, you can see why. Judges hear excuses every single day. After a while, they can probably tell within seconds whether someone is taking responsibility or just trying to dodge accountability. When someone stands there acting like they accidentally broke a clear, repeated order, that frustration is going to show. And in this hearing, it was pretty obvious he wasn't buying what the defendant was selling. At the end of the day, courts are about accountability. If you're given a warning and another chance, That's an opportunity, not an invitation to test the system. All right, guys, that's going to wrap it up. Let me know what you thought about this hearing. This one was definitely intense. If you enjoyed the breakdown, don't forget to like and subscribe for more daily content. I appreciate you all for watching. Seriously, thank you.
Take care.